The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
Count 1, aggravated murder, a capital offense for intentionally or knowingly causing the death of Charlie Kirk under circumstances that created a great risk of death to others. I had the opportunity to take out Charlie Kirk, and I'm going to take it. Roommate, why? Robinson, why did I do it? Roommate, yeah. Robinson, I had enough of his hatred. Some hate can't be negotiated out.
A first look at Charlie Kirk's accused killer in court as text messages were revealed by Utah prosecutors. The new evidence piling up against Tyler Robinson. Plus, a legal win for Luigi Manion, a judge dropping 2 of the terrorism charges in his state's case. So what does this mean for him going forward? We'll discuss. Plus, the men responsible for killing Crystal Rogers are being sentenced today. So will prosecutors be turning their focus onto Crystal's dad, Tommy Ballard, and his mysterious murder? Plus, Mama Donna demanding a new trial. We'll tell you why she wants to talk to the jurors from her case. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm Julie Grant. Are you ready for some coffee and some court? It is that time where we get you all ready and warmed up for the big day ahead on Court TV Live. So let's start it off as we always do. Grab that cup of coffee. It's time for my opening statement. Imagine what it's like. For just a moment, imagine what it's like to be the son of Crystal Rogers and Brooks Hauk. That precious child was 2 years old when his mother was taken away from him so cruelly, murdered by his father. Now that baby is 12 years old. According to local news reporting in Kentucky, Brooks Hauk has just surrendered custody of his son to his sister. How sad that innocent child has essentially lost both of his parents. He can never see his mom again here on Earth, and he can only see his dad during prison visits now. My heart breaks for Crystal Rogers' entire family, but it breaks the most for the son that she shared with her killer, Brooks Hauk. Today, on Brooks Hauk's sentencing day, let's keep Crystal Rogers' family in our hearts, in our thoughts, and in our prayers. And let's especially remember that beautiful 12-year-old boy. He doesn't deserve what's happened to him. And hopefully other family and friends can give him all the love and all the support that he needs. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
The DNA profiles from the child, baby Wise, and the mother, Tanya Wise, were compared with that of the alleged father, Jose Soto Escalera. The DNA profile from Jose Soto Escalera is consistent with that required of the child's biological father.
Now in Florida, we've got the state's case resuming today in the pregnant mistress murder trial. This is for defendant Jose Soto Escalera. Court's going to get underway 9 a.m. Eastern time. We will take you there live when it does. Also happening in Florida, we're on a verdict watch for the murder of beautiful Sunny Bell, 4-year-old girl shot in a drive-by shooting event. Deliberations begin again at 8:30 a.m. Eastern time. And we've got testimony in the dosed and choked murder trial for Herbert Swilley, continuing today in Florida. Swilley is accused of murdering his husband, Timothy Floyd, by drugging him, beating, and strangling him. That's going to start up at 8:30 a.m. Eastern. We will keep you posted. Right now, let's turn to your top story. New revealing text messages from Charlie Kirk's accused killer may be pointing to a clearer motive in the case. This, as we got to see, defendant Tyler Robinson. He is 22 years of age. He was appearing in court via WebEx on Tuesday. You see him staring straight ahead, just kind of blankly as the judge read off the charges against him. Now, Utah prosecutors earlier in the day released a handful of evidence in the case, including text messages between him and his roommate/lover. In those texts, Tyler Robinson confesses to shooting and killing Charlie Kirk, saying that he planned the whole thing.
The following text exchange, then took place. After reading the note, the roommate responded, "What? You're joking, right? Robinson, I am still okay, my love, but am stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you." Roommate, you weren't the one who did it, right? Robinson, I'm sorry. Roommate, why? Robinson, why did I do it? Roommate, yeah. Robinson, I had enough of his hatred. Some hate can't be negotiated out. If I am able to grab my rifle unseen, I will have left no evidence. Roommate, how long have you been planning this? Robinson, a bit over a week, I believe.
This defendant is currently being held without any bond. He's due back in court on September 29th. It's going to be another virtual hearing like Tuesdays. In the meantime, investigators keep working. So do the prosecutors, who have filed their notice of intent to seek the death penalty against him. So let's unpack the evidence, starting with those text messages. What do they prove? Let's bring in our guests. We have private investigator, also served with the NYPD. He's with Black Ops private investigators now, Manuel Gomez, and criminal defense and civil rights attorney Casey Early with us as well. Good morning to you both. Manuel, let me begin with you, starting with these text messages. As an investigator, how illuminating are these messages?
Well, first of all, I want to say my condolences to the Charlie Kirk's family and his wife. And these messages are extremely illuminating because, you know, it more or less makes it a slam dunk for the prosecutor. I don't see how they're going to have a trial when he's going to most likely have to take a plea. And if he does have a trial, it's a guaranteed win for the prosecutor. But what's more disturbing about this case, Julie, and that nobody's talking about, and that is the fact that Charlie Kirk received numerous death threats, and he did not take the preventative measures needed. This murder could have been prevented, okay? His security team failed him. They did not act properly. They did not put a protective shield around him. He knew numerous times. I've done a lot of research over the weekend on this case, and I have to tell you, Julie, there's numerous interviews where Mr. Kirk says, I'm receiving death threats. Nobody took it seriously. And it's sad because they did exactly what they did to Donald Trump in his conference with the people, and he got shot. Is exactly what happened to him. Nobody took it seriously.
Manuel, I appreciate that. You know, I want to ask you a follow-up question, please. Based on your experience, and look, you're with our special forces in the military, you've had so much training and experience. You've gone all over the globe doing investigations. In terms of the security, do you feel that it was lax? And if so, would you point to some particulars as to how lax?
Oh, it was extremely lax. The fact was he was sitting there cavalier when they knew, his security team even knew that he was receiving death threats. They had nothing in front of him. They had him so close to the audience. He was literally within 15 feet of the audience. And there's hundreds and hundreds of people here at this event. They did not take the measures to protect them. This was a murder that could have been prevented. And I hope, and it's an example to all the politicians and to the public speakers and activists, take those threats seriously. We live in the year of the murderer and the serial killer. This show shows it constantly how many we've had this year. The numbers are overwhelming.
Yeah, Manuel, you're right. A great insight. Thank you so much. Casey, early, you know I want to talk to you about the legal aspects of this. So let's first start by taking a look at the charges here. So he's facing aggravated murder, felony discharge of a firearm causing serious bodily injury, 2 counts of obstruction of justice, 2 counts of witness tampering, and commission of a violent offense in the presence of children. Prosecutors announced their notice of intent to seek the death penalty for him already. They had 60 days to do it from the date of charging, but they chose day number 1, as we know. So, Casey, the next legal move for Tyler Robinson would be what, please?
Well, I'm glad that the prosecutor in this case chose to not only file the notice of intent for the death penalty, but do it as early as possible, because what we don't want is any copycats out there that wants this notoriety or that want to have some form of validation based on their feelings. So in this case, we know that there's some legal and ethical concerns. I kept hearing yesterday that because he had a suicide vest on, that there might be a possible defense of a diminished capacity or some form of mental illness. Well, according to Utah statute, you can't use that as a defense for the charged crime of murder. I mean, it can be used for some form of mitigation if there is a plea resolution or if there is a negotiation where he takes a plea in lieu of the death penalty. But as far as a hardcore defense, his actions on the day of and after proves otherwise. The fact that he fled, the fact that there was a confession to his lover, he lied to his mother before the ultimate confession and turning himself in. So I'm just glad that the prosecutor took a stand, made it early, and there is overwhelming evidence in this case is that we're going to send a message that you cannot react based on a difference of opinion.
I love your analysis, Casey. Thank you for that. I want to play a clip. This is where the prosecuting attorney is talking about Tyler Robinson in the text message thread with his lover roommate, talking about the rifle that he's saying he used that belonged to his grandpa. He used it to kill Charlie Kirk, so he says, and we know now that his DNA is on the trigger as well. Let's take a look.
I had planned to grab my rifle from my drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything about them finding it. Robinson again. I'm wishing I had circled back and grabbed it as soon as I got to my vehicle. I'm worried what my old man would do if I didn't bring back Grandpa's rifle.
Oh, that's what he's worried about, bringing back the rifle that belonged to Grandpa. I wonder what Grandpa would say about this. Manuel, in terms of how he executed this, I think it can be kind of puzzling when we see the video of him up on that rooftop and you see him coming off the roof, not having the rifle. Curious if you have a theory about this. Did he toss it from the roof, do you think?
I think he did, because when they showed the area where he was laying down, I think he jumped up, realized he had a hit, and ran. And that was the problem here. But this kid here, I mean, this case is an investigator's dream come true. And the reason why is because the amount of evidence of him admitting to this is just insanely beautiful, because this case is a slam dunk, as I said. His motive, his method, I mean, you could tell that he prepared for this, but he wasn't too smart. I mean, he's walking around with a shirt with a big American flag on his chest. So, I mean, he did make it kind of obvious there. But again, his downfall will be that in this state, they're going after the death penalty, and I hope they make the example that needs to be made on him.
Yes, I'm with you, my friend. Excellent points from you both. Of course, we'll continue our coverage of this case, and as this one progresses through the system, Court TV will be following it all. Manuel Gomez, Casey Early, stand by, please. Here's what's coming up next on Opening Statements.
We have the habeas petition now that is ended. The Menendezes could always appeal it if they so choose, and I trust that the appellate courts will reach the same result that Judge Ryan has reached here and find it utterly meritless.
The Menendez brothers denied their request for a new trial. So what's their next legal move? We'll talk about that. Plus, we're spotlighting the sentencing of two of the men convicted in the death and disappearance of Bardstown mother of five, Crystal Rogers. And as their case comes to a close, we're wondering, what about Crystal's dad, Tommy Ballard? Will his mysterious murder ever be solved?
The Court TV podcast will return.
Members of the Altoona Police Department arrested Luigi Manion. He is believed to be our person of interest in the brazen targeted murder of Brian Thompson, CEO of United Healthcare.
It feels good to get a guy like that off the street.
Luigi Manion, the defendant, is charged with 1 count of murder in the first degree and 2 counts of murder in the second degree, including 1 count of murder in the second degree as an act of terrorism.
Luigi Manion is waking up this morning with a lighter list of charges against him as a state judge in New York tossed 2 terrorism counts against him. Now, he's, of course, the defendant in the United Healthcare CEO murder case. And on Tuesday, that ruling dismissed 2 charges, sparing him the possibility of a mandatory life sentence without the possibility of parole. In a written decision, Judge Gregory Caro said in part, quote, while the defendant was clearly expressing an animus toward United Healthcare and the healthcare industry generally, it does not follow that his goal was to intimidate and coerce a civilian population. And indeed, there was no evidence presented of such goal. Manion still faces murder in the second degree charges, and he's also still charged with murder in federal court. And it's the federal case, not the state case, that makes him eligible for the death penalty. Because remember, at state level in New York, they don't have the death penalty, but they do in federal court, okay? So he's still got lots of legal problems. So let's talk about how much of a legal victory this decision from this judge in state court is for this guy. Let's bring back in attorney Kesia Early and private investigator Manuel Gomez, and welcome in criminal defense attorney and former prosecutor Franz Borghardt. Franz, let me start with you. Should Luigi be celebrating this little victory?
So as a defense attorney, I get excited sometimes when I get a motion to continue granted. That's a win, right? But I would say
the bar's a little lower, huh? On the defense side,
right.
Yeah.
So I would suggest this. Mr. Manion should not be doing any victory laps. He's still facing incredibly serious charges, and none of this has any bearing on the federal case where he's facing the death penalty. Now, I will tell you this. What's interesting to me, Julie, is if I were a prosecutor, yeah, I may take this little knock on the chin and keep it moving, but I would consider maybe a possible writ on this. They're not going to do that because I don't know if the domestic terrorism argument has been fully vetted. This is kind of a newer concept, so it is right for an appellate court to make a decision on this. However, they got more than enough ammunition to go after this guy, and so I think they're just going to keep it moving.
Right. Sharp points there, Franz. Kesia, let me go to you next on something that I think has a lot of people scratching their heads. Which case is going forward here? I don't think we know at this juncture. And the weird thing is, this more severe penalty is in federal court, and typically in cases, at least in my experience, if I've got a case that's arguably, something that the feds would go first, they're going to go, and the state case is going to wait. Are you a little bit baffled by this, where it almost seems like in the last we heard here at Court TV, we heard it was the state case that was going to move forward first. Do you find this bizarre at all?
Well, Julie, typically with my cases, and I agree with you, when we have a state case as well as a federal case, the state case is put on pause. There's an order written by the court that we will see what happens in the federal case, and then we will pick it back up for the state case. So I don't know which one is going forward, but I do agree with the judge. That was the proper ruling, because with the terrorism, we know that 6 days after 9/11, lawmakers were able to not only draft and formulate the law, but it was solidified because it was supposed to be a plot to kill like the masses, the civilians, and cross-border terrorism. I never thought that was fitted in this case. So I do believe the judge got it right, and I do believe the federal case is going to go first because it has the most severe punishment. And typically, if he is convicted on a federal case, then that either would take care of the state case as well because it's the same type of charges and allegations. So that was a slight win per se, but it was obvious that was an overcharge in my opinion.
Yes, great points, Casey. Manuel, perhaps you can speak to this from experience, having served in the NYPD. You're a New Yorker. Do you find this at all bizarre that we would proceed first with the state case, which doesn't allow for the death penalty, and then proceed again with the federal case, and federal prosecutors are hoping to get it for this guy?
Actually, I do find it kind of bizarre because he was interstate stalking the CEO, and that's why he's charged with that. So it should have went federal. But I do agree with my colleague when it comes to the terrorism charges. They weren't proper in this case. But the evidence is overwhelming. The fact of the matter is Luigi Manion sits there with no remorse, sits there with his face calm as a cucumber. The guy just doesn't care about what he did. We need to make an example. I hope the feds step in, give him that death penalty so that we could say in New York and the United States, we will not tolerate Luigi Manion's and we will not tolerate Tyler Robinson's. These type of vigilante tactics must stop.
Yes, amen. Amen, my friend. I love what you said. And great point about the interstate stalking. That's one distinction. A lot of people are comparing this case with the Tyler Robinson, Charlie Kirk assassination case, as you all know. And here, there's the difference in that the traveling that you mentioned, Manuel, that Luigi Manion allegedly did versus what Mr. Tyler Robinson allegedly did, being a resident of that state. Let's turn to another trending story, shall we? Let's talk about the Menendez brothers. So these guys are finding themselves on the side of a bad, I'm sorry, I shouldn't say let me say that again. Another decision that was another blow to them, okay? They got another legal blow on Tuesday. The court denied them their motion for a new trial. So remember, they were finding these different avenues to try to get released. First, they tried the parole board. Then they tried what's called this habeas corpus petition, petitioning the trial court to give them a new trial, saying it was because of some newly discovered evidence. Well, the judge said what they presented wasn't relevant to anything that would have been pertinent to the issues that were happening at trial. So these brothers, they continue to claim that they were sexually abused by their dad. The district attorney, Nathan Hochman in LA County, points to the allegations that they made as being behind the recent ruling by the judge. Let's take a listen.
So what Judge Ryan did yesterday, in agreeing with our position, our ultimate position, and ending, for now, unless they keep appealing this, the meritless motion that the Menendez brothers filed, he basically said that the evidence alleged here is not so compelling that it would have produced a reasonable doubt in the mind of at least one juror. That is how deficient, how meritless, how baseless the evidence that has been presented by the Menendez brothers has been in this habeas motion.
So these guys can continue on their quest for freedom by way of petitioning Governor Gavin Newsom for clemency. They'll also go before the parole board again in 18 months from now. So what might their next move be? Are they going to go to the governor? Casey, what do you think?
I believe they are. I mean, they have nothing to lose at this point. It's a long shot, I will say, after all of the motions to the higher court. But I do believe the court got it right because they focused on the two main things: premeditation and deliberation. And even with those two newly discovered evidence, the fact that the court believed that that wasn't even sufficient to sway one to raise any form of reasonable doubt for a possible hung jury, or to even sway the decision in any way shows that that evidence is weak. But of course, if I were them, I would definitely go. You have nothing to lose. Might as well exhaust all of your resources and then try again for parole.
Right. Yeah, you can't blame them for trying, right? Franz, what do you think? Are they going to the governor?
I would suggest, if I were representing them, which I'm not, I would suggest, and I use this term very cautiously, Julie, I would reach out to the fan base, because these guys have a fan base. I don't know how else to describe it. They have a weird following. And those individuals will likely put pressure on this governor who, and look, I'm not trying to get into politics, but look, by the end of the day, this governor has been very vocal about the Menendez brothers. And that fan base, if I were advocating for them, would put pressure on the governor to possibly do something, because the governor at any moment can blink and pardon these guys.
Right.
He hasn't done that yet. He hasn't done that yet, and he hasn't done that yet in part because I think it was easier to let them exhaust all these legal remedies, and maybe they'll get parole, and maybe I won't have to get my hands dirty. And you don't get your cake and eat it too, Julie. You don't get to advocate for them as a governor and simultaneously not pardon them. That's the problem he's now in, and there's some politics behind it, and he wants to run for a higher office, so I don't think he's going to pardon him.
I agree, Franz. Yeah, good points. Manuel, let me go to you here. What do you think the next move for these two convicted killers will be?
Well, I believe they will, like I said, try to go for the governor, like my colleague just said. But I believe, like he said, that he's not going to pardon them. You know, we have to remember something very important in this case. They methodically planned the murder of their family members. They didn't do it while the act of sexual assault was occurring. They went and they shot their family members and killed them. And the murder was so egregious, so vicious. These guys should not be out. Granted, if what they said happened to them was correct, then, you know, two wrongs still don't make a right. They were wrong. We need to set an example again. We can't have this type of vigilante tactics being done. I'm sorry, but they should not be released.
Yeah, I'm with you, Manuel. I'm on the side of justice. You do the crime, you do the time. And I think that with Menendez mania, a lot of people forget the cold, hard facts, or they haven't heard the actual facts because they're, you know, taken over by the entertainment that's presented on television. These guys went from they didn't do it to it was a mafia hit, they manufactured an alibi. I mean, a tremendous amount of deceit and planning went into these murders. They also encouraged suborning perjury with other witnesses. They asked Lau's girlfriend to testify that Kitty Menendez poisoned the family. They actually gave her a script of what to testify to, and she did testify in the first trial. Then there was another friend they did ask to say that this friend was so fearful of the Menendez parents that they wanted to borrow a handgun from this friend. They wouldn't do it. Asked another girlfriend to testify that dad raped her. She refused. You know, these guys lied about so many things. I don't know that you can trust anything that comes out of their mouths. We will leave it there for now, and we'll report if they go to Governor Newsom next. A great discussion and analysis with you all. Manuel, we got to say goodbye to you. You've got cases to work. Be safe. Thank you so much, friend. We'll talk soon. And still to come here on Opening Statements, this is what we've got.
We're investigating the murder of Tommy Ballard that could potentially be related to this case.
Crystal Rogers' dad's murder still remains unsolved as the two men convicted of killing her are facing sentencing today. And will Mama Donna get a new trial? Well, she filed a new motion for one. She's blaming the judge, and she's blaming some of the jurors. We'll unpack that for you, too. Stay with us.
Now, back to the Court TV podcast.
Welcome back. In our spotlight this morning, it is sentencing day for two of the men who've been convicted in the murder of Kentucky mom Crystal Rogers. Rogers was the mother of 5 beautiful children, and she vanished over 4th of July weekend back in 2015. Her car was later found abandoned, and her remains have never been recovered. Brooks Houck was Crystal's boyfriend at the time and the father of her youngest son. He's been convicted of murdering Crystal. He's been also convicted of tampering with case evidence. Joseph Lawson, a buddy of his, was also convicted of conspiracy to commit murder and tampering with evidence. Let's take a listen to Houck talking to police after Crystal's disappearance.
Had you and Crystal ever talked about breaking up?
I mean, obviously we have fought just like any other couple, but in the last several years, I mean, it's came up, but we've always found ourselves together moving forward.
Crystal's father, Tommy Ballard, was searching for his daughter every single day, arguably her best advocate. But his own investigation was cut short when he was shot and killed in November of 2016, so about a year after she disappeared. His case still remains unsolved. So will the family ever get complete justice for his murder in addition to her murder? Let's talk about that. Let's bring in someone who's followed the case since its inception, forensic death investigator and professor at Jacksonville State University, Joseph Scott Morgan. Good morning, Professor Joe. I'm curious if you have been suspicious of the way in which Tommy Ballard was killed, as he was, some believe, getting very close to solving this.
Of course I have been, and this is why. Remember, this is a man. He was a grandpa, and he had his grandson with him. They were going to go out hunting, Julie, and it's a very specific path that they took. The reason I'm suspicious is that someone would have had to have had an awareness of timetables here. When is he going to exit his house? When is he going to be on the path? What is my point of view if I'm the killer? Because this round that took him out was fired not from a great distance, but from some distance, and literally dropped him where he stood with his young grandson as a witness to this. Just sink your teeth into that for a second to give you an idea of how cold-hearted this is. And there's no other known violence surrounding this man. And in the midst of trying to find his precious daughter, who, to this day, Julie, still, we don't know what happened to her or where she is. We've got kind of a handle on what may have happened, but have no idea. So I think that moving forward, I hope that the prosecution in the state hasn't used up any kind of leverage they have relative to the conviction on Crystal's case that could be exerted relative to Tommy's case to try to, close the door on this and get some definitive answers as to who the trigger puller was and any of their conspirators as well.
Yes, Professor. Curious if you think we got perhaps a big clue during one of the court hearings, and this happened a while back. This wasn't in recent months. This is a while ago. We saw the prosecuting attorney discuss a firearm that they believe might have been used to kill Tommy Ballard. And there's a link to Brooks Houck's brother, Nick Houck, who is the disgraced former cop. Let's go back in the courtroom and look at that moment.
I will tell you, Your Honor, we're investigating the murder of Tommy Ballard that could potentially be related to this case. We are waiting for testing to come back on the firearm we believe was used to murder Tommy Ballard, a firearm that we purchased from Nicholas Houck, who was using a fake name when he sold the rifle. We know it's the same caliber. There's 5 criteria that they're looking at, and so far it's matched 4 of the 5 criteria.
And that was the last we heard about it, Professor. As you know, they said it's matched 4 of the 5 criteria. Thoughts on what the holdup may be in making this definitive determination?
I think that maybe it does rest perhaps in the ballistics. The problem is I don't understand if there is a recovered round that was related to Tommy's murder, if that round is is perhaps deformed to the point where it cannot be married up with a test-fired round out of that same weapons platform, and that's going to be key. I think that would be a real insight, and that, of course, would be data that you could get from the autopsy report and from any other kind of ballistics reports that might exist. And the fact that it's just kind of fallen off the face of the planet is not reassuring to me, because they're waiting for that one thing, that one bit of data that can seal the deal here, moving forward. If you can put that weapon in a potential perpetrator's hand, this goes to ownership, right? It's that font from which everything else flows from an evidentiary standpoint, where you can connect the dots along the way. That in and of itself is very powerful stuff. And they're going to continue to press on this case. This thing has still got a life. It's still got a life to it, Julie. It's not going to just suddenly cease.
Right, and I'm so happy to hear you say that, Professor Joe. I think a lot of our fellow, courties and members of the true crime community feel that way too. They're hoping to see justice. It's taken a while, but look, it was had in Crystal's case 10 years later, and so certainly anything is possible. And I urge all of our courties at home to take a listen to your podcast on this case, Body Bags. You've talked about it, and I'm sure we'll continue to do so. Professor Joseph Scott Morgan, thank you so much.
Good to be with you, Julie. Thanks for having me.
We're going to hit a break, friends. Go get some more coffee. When we come back, it's time to talk about Mama Donna.
We, the jury, find as follows as to count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
Less than 2 weeks after Donna Adelson was found guilty, she's demanding a new trial. Will she get it? That's next.
This is the Court TV Podcast.
Let's talk about what's tipping the scales. Mama Donna's not given up yet. She may be a convicted killer, but that's not stopping her from throwing the illegal kitchen sink, so to speak, in a Hail Mary bid for a new trial. A new court filing reveals that Adelson has filed a motion asking for a new trial and for permission to interview 2 of the jurors who convicted her, claiming that there was alleged juror misconduct from jurors 5 and 7, both of them talking after the verdict. Juror 5 allegedly saying they took Adelson's reactions into account, and Adelson wants to ask juror 7 about her social media activity during the trial. Here's a TikTok that she posted after the verdict.
Overall, it took us about just over 3 hours to deliberate and reach our final verdict, right? But within the first hour and a half, I want to say everyone was agreeing that she is guilty. We had 2 people who said they thought she was guilty. They're like, but I'm kind of confused on this one thing, this like point 2 on count 2. And we went over things point by point, okay?
All right, so what's going to tip the scales here? Let's talk about this. Let's bring in Franz Borchardt and Casey Early and unpack this motion. So with respect to the TikToking juror, Franz, she went on TikTok and announced, according to the Adelson motion, that she was going to be a juror in this case. And then she posted after the verdict. So announcement, is that enough to tip the scales in Donna's direction?
Not even in the least. It doesn't look like good optics, but ultimately, hey, I'm going to be a juror, and she's not told by anybody not to make the post. She doesn't make any post during the actual trial, and then after the trial, she makes a post. I don't think that tips the scales at all. And candidly, that's the world we live in now in 2025, where jurors do that kind of stuff. We saw that in the Karen Reed trial. It's not going to tip the scales. It's not going to get her a new trial.
Appreciate it, Franz. Let's take a listen to some more of what that juror said. This is the foreperson as well, so let's make that clear. Here we go.
I also have a lot of people asking if my mind was made up before we deliberated. No, no. I stayed neutral through the end of the trial, just like we're supposed to. You know, everyone's presumed innocent until proven guilty. You know, I kept my mind's open, and I took notes on everything, you know, from when both the prosecutor and the defense were arguing their points. I took notes on everything. A lot of people seemed really focused on my age, which is very strange to me. We had a super balanced jury, like a big age range. I was not the youngest one on the jury. And once again, if we're looking at the jury requirements in the state of Florida, you only have to be 18 at minimum. So, I mean, like, if you don't like that rule, whatever.
Okay, so with respect to her, Casey, do you think that the judge is going to allow the defense to inquire into her social media postings? That's what they want. They want to question her.
Yeah, I don't believe, unless I hear something compelling, but at the same time, I always say the voir dire process is the most important process of a jury trial. So if the defense didn't ask those questions and vet the jury properly, then they can't come back on the back end and say, well, they said this. Well, did you ask? Did you inquire? And did you raise a motion to strike for cause or use one of your preemptive read challenges? Like, if you didn't do that, then it weakens your challenge. But let me say this, kudos to the defense attorney. That was a well-written motion. After I read it, I started to forget about the overwhelming evidence against Donna in her trial. I mean, there were several points, but I really enjoyed reading the legal analysis. But the one thing that stuck out to me was denying access to the record. Because if, in fact, objections were raised and it was sustained without the defense at least alerting the court rather about what their basis was, then that is a problem for concern, because everyone is entitled to a fair jury and a trial. So I think that would be their greatest argument. But otherwise, evidence is overwhelming, even if she gets another trial.
Great points, Casey. Franz, let me ask you about Juror 5. So another juror, this juror, a male juror, he appeared on the podcast Surviving the Survivor that Joel Waldman does. And in the appearance, he talked about how he considered Donna Adelson's reactions to the evidence and the testimony that were coming in at the trial. We know she didn't testify. She was not on the witness stand. But then he subsequently made a statement that he obviously did not consider her reactions during the deliberations, said they're not evidence. And the defense is raising this as an issue, saying that, look, the court gave instructions, numerous admonitions to Mama Donna during the trial not to show any emotion. She was prohibited from doing that. This attorney thinks there's a question of whether the jurors held it against her. What do you think, Franz?
You strike me as a little bit of a rock and roll kind of gal, Julie.
Oh yeah.
And there's a song by Bon Jovi that I celebrate on a daily basis called "Living on a Prayer."
Great
and
song.
that is what I feel like I'm listening to. Now look, the defense, as Casey has said, the defense is doing the right job. They're raising the issues. The problem is, again, this juror was very honest. I did look, but I didn't use that as my basis. I'm paraphrasing. I did look. That's human. It's human to look over and be like, man, she doesn't look like she's showing a lot of emotions. However, when that juror said, but I didn't hold it against her, that's going to cleanse that situation. Now, again, as Casey is brilliant, again, you got a voir dire on this. My client's going to sit over here during this trial, and I've advised her to sit like a robot and to not show emotions. And, you know, and so if they didn't do that, it's going to be problematic for the defense.
Really great points from you both. Franz Borghardt, Casey Early, thank you both so much. I'm going to go play Living on a Prayer. You got me in the mood for some music, Franz. Thank you for that. We'll do it during the break and get some more coffee. We'll see you both back here on Opening Statements soon. That's all for this episode of Opening Statements, my friends. I'm your host, Julie Grant, and it's been great being with you. On this show, I am calling out any pants on fire moments in our big trials and true crime stories, and I want you to come along with me. Opening Statements is live every weekday morning at 8 a.m. Eastern on Court TV. Thank you for downloading this episode. Please subscribe, leave a review, and share it with your friends. You can watch past shows anytime you like on CourtTV.com.